going on, guys? It's Berserker Marion. In this video, we're going to talk about speculative questions. They're often used in traffic court by a judge or state attorney to lead a defendant into self-incrimination. And this is how to recognize it, how to object to them, how to combat to them, use proper legal language and constitutional rights. Now, this isn't always a surefire method, but this is a good start into learning how to recognize the language and recognize the sentencing and structuring. Legalese is very crafty, very crafty. Prosecutors and judges may ask speculative or probing questions that are designed to fill in gaps in their case using your words. They do this in every case, especially traffic cases, because they need you to give them personal jurisdiction through admittance. They're framed in a way that assumes facts, not in an evidence. They're intended to get you to confirm or deny things that will later be used against you. Remember, anything you say can and will be used against you in a court of law. They're crafted to appear harmless but elicit admissions of guilt. Okay? Your goal is to recognize the trap, shift that burden of proof, and protect your Fifth Amendment rights under the legal maxim, nemo tenetur sapiensum excusera doctrine. No one is bound to accuse themselves. Okay? Here's some examples of probing and speculative questions. They're common trap questions that are very well known. And here's why they're also problematic. How fast do you think you were going? It assumes guilt, asks you to estimate your own violation. You were aware of the speed limit, right? It forces you to admit knowledge as mens rea element. Okay? Did you see the stop sign? It admits you were driving and knew about a control signal. Were there any distractions while you were driving? Attempts to create negligence or recklessness. Is there a reason you didn't slow down? Loaded. It assumes you failed to slow. Okay? You were driving, correct? It locks in the identity of the driver. You agree the officer clocked you at 15 over, correct? It attempts to get you to violate hearsay or an officer's claim. You were trying to get somewhere in a hurry, were you? Probes for motive, intent. You agree the officer clocked you in, it attempts to get you to violate hearsay or an officer's claim. See my previous video on hearsay. A citation could easily be argued in court that it's hearsay. The machine or radar LiDAR in the car did some work, made some funny noises, and a cop interpreted those noises as you breaking the law. You cannot question that LiDAR radar in court, because if you question it in front of a jury, they wouldn't be able to assume any information from it, because it's a machine that beeps and boops and bloop bloop and belts and whistles. And if you was to use that in court, the judge would throw it out and say that's not legal. You can't use that in court of law, it's hearsay. But yet, police officers do it every day. They're language tricks that make a question speculative. There's plenty of tricks, okay? They assume facts, not in evidence. You didn't stop fully at the stop sign, right? Invite conclusions or speculation. Wouldn't you agree your speed was unsafe? Use emotional framing or leading language. You must understand why this is dangerous, right? Ask for reasons for justification. What was your reason for not stopping? They require you to reconstruct your events. At what point did you realize you were speeding? And this is some of the methods that you need to learn. A general format for objections. Objection, Your Honor, the question is speculative and calls for a conclusion not supported by evidence. You have to slow your mind down, listen to what he says, and dissect it as he's saying it, so that way you can object to things. Okay? Objection, Your Honor. That question calls for self-incriminating response, violates my Fifth Amendment right against compelled testimony. Keep that ready. You know, you need to keep this comment right there ready at all times. You know, objections you can raise and when you can use them. All right, speculation. Questions ask you to guess or hypothesize. It assumes facts not in evidence. The judge, prosecutor embeds in unproven assumptions. Leading, especially when judge helps the prosecution. Did you notice the sign? You did notice the sign, didn't you? You know, don't let the judge ask speculative or investigative questions. If he does, object to it. The judge must be neutral and unbiased, no matter if he's getting paid by that corporation or not. You know, their language calls for conclusion. Do you think you were being reckless? Relevant. Why were you in a hurry? Has nothing to do whether you violated a statute or not. Okay? So when he does, you go, objection, that's irrelevant, Your Honor. It has nothing to do with whether I violated a statute or not. Self-incrimination when asked to describe your behavior, speed, intent, etc. So if they ask you to describe any of that, self-incrimination. Objection, Your Honor. Okay? Here's some sample objection statements that you can say in court. Objection, Your Honor. The question is speculative and assumes facts not yet in evidence. Objection. That question is designed to elicit self-incriminating testimony. I respectfully assert my Fifth Amendment. Objection. That question requires the defendant to provide the prosecution's missing evidence and burdens the defendant with disproving the state's case. Objection, Your Honor. That's a compound question, vague in scope, and assumes reckless behavior without factual support. Objection, Your Honor. This question seeks a legal conclusion that is reserved for the trier of fact, not the defendant. You know, you can also use motions. You know, the motion in limine. Use this before trial to limit or exclude certain questions or topics. You can use this to limit a traffic cop or a state attorney from asking specific questions that are speculative. Write down all these speculative questions that you can formulate. Use ChatGPT or AI to write down, 100 different speculative questions, and then go through them and then find different ways to say them and write them down, and then turn that in and say, I would like all these questions, prevent it from being asked, because these are not questions that will be useful for the case. The purpose of a motion in limine is prevent questioning that forces you to admit guilt, requires speculative answers, and violates due process or Fifth Amendment protections, okay? A sample language would be something like, defendant moves the court to exclude any speculative or self-incriminating lines of questioning regarding the alleged offense. Included questioning about subjective awareness, perceived speed, or interpretations of signage. These questions violate defendant's Fifth Amendment rights and are not necessary to establish any element of the charge, which remains the state's burden to prove. Okay? Motion to suppress admissions. If you accidentally answer a probing question that later gets used against you, you can argue that statement was elicited improperly. You weren't informed of your rights, especially if you were already in a custodial setting. The question was prejudicial and speculative. Okay? Use this for your advantage. They're not expecting you to be informed and intelligent. They don't want an intelligent defendant, okay? That pisses them off more than anything. Here's some safe, non-incriminating, deflective responses. They're designed to shift the burden of proof from, instead of answering the question, you're shifting the burden of proof back upon the state. And anytime you object, you're doing that. So like the judge or prosecutor asks you, were you speeding? I can't confirm that. I decline to answer under the Fifth Amendment. How fast were you going? I don't want to speculate. The burden of proof rests strictly with the state. Did you see that sign? I decline to answer. That's a matter of evidence, not admission. Was that your car? I'm not prepared to answer that. The prosecution must establish identity. Why didn't you stop? I'm not sure I understand that question. Objection. Question presumes facts not in evidence. Here's a little pocket statement. Have a phrase you can always calmly repeat in court when you're under pressure. I respectively assert my Fifth Amendment right to remain silent and decline to answer any questions that may tend to incriminate me, and the state bears the burden of proof. Okay? You're not being a sovereign dick, so they're not just going to crap on you. They're seeing that, you're not going to answer anything that is speculative or self-incriminating. And if the state wants you to pay that fine, they're going to do their damn job. And you're not going to answer any questions. And I cannot confirm or deny it was me in that vehicle. I don't want to incriminate myself. Answering that is speculative. If you can't prove without a shadow of a doubt I was inside that vehicle, you have to, prosecution must establish identity. I'm not answering if I was in that car. Do you got me on camera on that car? No? Well then, fuck off. Figure out how to establish identity another way. I'm not going to help you that way. I'm not going to help you with your own case. If you suck at your job, you suck at your job. A good prosecutor don't give a fuck how you come, and it'll burn your ass up unless you're really good at arguing the FUs and the may nots and the BDs and the ADOs. If you can litigate somewhat and argue and not answer speculative questions and know what they sound like and at least be able to identify them and object to them, you have a winning chance. Objections of speculative questions are your number one thing that you really, really need to listen to and try to defend yourself against. Because those questions are the ones that destroy you in court. They're the ones that get you guilty every time. Most people, that's how they lose. They try to answer certain questions and then they answer it wrong. I've come up with videos I've listened to and watched and AI conversations. I've come up with a list of questions and potential fucking answers. And we're going to go through them and they're going to help you. Listen to the question. The question is what the judge or a prosecutor would ask. And listen to the layman response and then the legal response. And get an idea of, the difference there and how to protect yourself even in a layman's terms. How to identify those conversations. Like, were you operating a vehicle at the time of the alleged violation? A layman would say, I'm not here to testify to that. I need to see the prosecution's evidence first. Legal objection, that question assumes facts not in evidence. The burden is on the state to prove of operation beyond a reasonable doubt. Why didn't you just pay the fine? A layman would, I'm exercising my right to challenge any claim made against me. But the legal comment should be, the state's burden of proof is not satisfied by voluntary forfeiture. I'm entitled to due process before any penalty is imposed. Okay? The judge asks you, are you denying that the violation occurred? A normal person, the right way to say it in layman terms is, I'm asking the court to require the state to prove it occurred. The legal sentencing should be, the legal phrasing, I neither admit nor deny any allegation. The prosecution has the burden to establish a prima facie case based on admissible evidence. Questions like, did you receive the citation? And if a judge asks you, are you denying the violation occurred? We go back over here, it's purely speculative. You could say, that's assuming guilt, and it asks you to estimate your own violation right there. That question, are you denying that violation? He's asking you to agree that there was a violation. That's probing. And the judge, if he does it, you can object and ask him to recuse himself for not being biased. Because if he's asking investigative questions, you look him right in the fucking face and you say, hey, are you the trier of the facts or the trier of the case here? Because I can't have you being both. That takes away due process. I motion to dismiss for failure to state a cause of action, state a claim of action for which relief can be granted. Those are speculative questions. You object. Your Honor, that question is speculative and calls for a conclusion not supported by evidence. And that's exactly what you say to him when he asks you that. You say, you can even say, I neither admit nor deny any allegations, and I object. The prosecution has the burden to establish a prima facie case based on admissible evidence. And I object. That question is purely speculative and calls for conclusion not supported by the evidence. And that's what you say to them, and they go, oh, man, that's going to be a day. They're not going to expect you to talk like that. Questions like, did you receive the citation personally? You could say, the layman way is a piece of paper was handed to me, yes. But it doesn't establish legal sufficiency. The legal phrasing is, receipt of a citation is not an admission. Service alone does not violate its content, nor satisfy evidentiary standards. You can use the layman terms, but it's always better to speak to them in a legal sense. That's a language they understand, and just irritates them to have to deal with layman language. Speak to them in legal language and get it done and over with, and try and keep it short and simple. Only speak when spoken to, only object when you have to, motion when you need to, and stand your ground. What if a judge, you issue a motion on a traffic citation? You can expect to hear something like, why you challenge this on procedural grounds? And you either say, because procedure protects everyone's right, including mine, or you can say, due process is foundational, constitutional requirement. The absence of procedural safeguards renders any prosecution defective. They ask you, do you understand the charge against you? No, the citation lacks enough detail for me to understand what's being alleged. You're telling me there's a charge against me, then there's a damn crime being committed, and I'm not aware of any crime that I committed. The citation fails to establish the specific elements of the offense or the factual basis required to provide sufficient notice. If there's not a lot of information, it's just your name, your vehicle, a code, and the signature of a cop. There's not a lot there. And he can't enter any extra information because he didn't put it on that citation. He has to put in all information and submit it at the beginning of the case when he goes to court and says, hey, I'm charging this guy with a crime. But remember, officers can't charge a individual with a crime. A judge or a magistrate must. It must come from the judiciary. It cannot come from the executive branch. So when they admit that you were charged with a crime, using that question, start processing that as a due process denial. Okay? Start thinking about that. Because an executive officer, a member of the executive branch, cannot issue a citation or a summons criminally. It must come from a judge or a magistrate who has verified the charges, okay, and verified the evidence. And I heard this judge say this last time I was in court, where the state decided to continue a traffic claim because they can't fight a dismissal out the door because they don't have enough legal capacity, I reckon. But I kept hearing him say this multiple times. Isn't this just a minor infraction? And he would say, and he would say, it's no big deal. I've had them before. We've all had them before. It's just a small deal. Just pay your fine and go about your way and have a good day and try not to get in trouble anymore. You have a good one. The right thing to say, even as a layman, that may be so, but I still have a right to due process. Legal phrasing, the nature of the charge, regardless of severity, does not negate the state's obligation to establish a legal valid basis and provide procedural fairness. You're definitely going to hear, what is your defense then? Because they're not going to like you standing pro se. You can say it, I'm not here to present a defense until the state presents a valid case. you know, especially if you're denied the right to cross-examine, or you know, you issue a motion right out the gate, and the judge wants to hear your argument. You know, they're going to ask you questions like, what's your defense? And you say the defendant is under no obligation to assert a defense unless and until the prosecution presents a prima facie case supported by evidence. Okay, and in my case, citation didn't say nothing. It just said the speed that I was traveling, the vehicle I was in, my name, a P.O. box, an address to send the ticket to that I did not agree to, and they put no information about how he obtained my speed. Nothing. I mean, there's nothing. There's a code, but it's missing the subsection code. So, from what I can understand, I can't provide no defense. I'm lacking the opportunity to provide defense because the state didn't provide a prima facie case supported by evidence. There was no evidence written down. There's nothing. It's just an allegation with no supporting evidence. So I can't build a defense. So I filed for a motion for dismissal, and I guess I'm gonna have to argue it. But you know, I'm gonna definitely argue. You know, the reason why I submitted this dismissal right out the gate is I'm under no obligation to assert a defense, and that's something that I put in my dismissal. I put at the bottom, I'm under no obligation to assert a defense unless or until the prosecution presents a prima facie case supported by evidence, which they did not. And I'm asking that they are not allowed to enter into any more evidence because they didn't enter it in the beginning. If you couldn't do that out the beginning, then that means you've had this amount of time, X, Y, Z, to create evidence. And that's not okay. You know, you know, I wouldn't ask this one, but I've heard it before in court. Did you request a formal hearing as required? And most of them all say the same thing. No, because that citation lacked instructions for initiating one. But they didn't know what to do from that point. They didn't understand that they could tell the judge any procedural burden placed on the defendant without adequate notice or guidance violates fundamental fairness. I'd like to motion for dismissal for denial of due process. Because that's the thing, is it's the state's job to do the procedurals. It's not your job to defend yourself. You're innocent until proven guilty, and it's the state's burden of proof. And if the state is forcing you to show burden of proof, then you're not being afforded due process. You know, questions like, were you speeding at that time? You can just say, I'm not answering that. It's the state's job to prove that. Or you can say objection, in which I would always say object, because that goes on record that you're objecting. And even if it doesn't go on record in a court of no record, it's still there for later. You can say, well, you know, you could have a pen and piece of paper and write down every time you object and the time that you did and the time that the case started and all that. You can keep a ledger of it. And when you go to file an appeal, if you lose and you feel like you can win your appeal, you have all that documented. The court didn't do their job to record anything because it's administrative court. But I did, because I knew I was going to appeal their decision, because I knew I wasn't going to get a fair trial. So be prepared. You know, be prepared 100%. At all times, be prepared to object, and at all times, be prepared to appeal. Don't get mad. Don't have emotion. Just, okay. You let them do the thing straight poker face. Show no emotion, no matter what they say, no matter what way it goes. Show no emotion. Just be stone cold up in there. Be Stonewall Jackson. Stonewall Jackson got his name for being so cold on the battlefield. He would stand at the front of the line of all of his men, and he would hold his hand up and pray to God before that battle. And never got hit. And he was never scared because he knew God had him. And he eventually got shot. He lost two or three fingers on one hand, got lead poisoning, and it killed him, which was pretty common. But he put his faith in God, and God said, hey, you go do my work. You go do your deal, and when your time is done, I'll come and take you, my son, and everything will be A-okay. And you know what? That's what happened. Stonewall Jackson was an honorable man, and he was a patriot to the country. No matter how you feel based on what side of the argument he was on, I believe that he had a lot more integrity than many a man that fought in that war. But I feel for every man that fought in that war because, a lot of good men died, and a lot of my family died in that war on both sides. I had members that, just like in the American Revolutionary War, I had family members that were fighting for Britain, and I had family members fighting for America. I had family members coming down from Canada fighting with the French on behalf of America. I have several grandfathers that came down from there. I got grandfathers that helped establish Canada. I got a rich history, and there's a lot going on, but I have ignorance of the law, so I'm learning, and while I'm learning, I'm trying to spread that same information so we can all learn together. We all go through things. In my particular situation, I was it's alleged that I was speeding in nowhere zone. There's nobody on the road. No big deal. Not worried about the claim and the allegations. But I have issue with procedural methods, and if they're not correct, then I expect a dismissal. A lawyer would fight it and get it thrown right out as long as I pay the lawyer. But I'm not paying a lawyer to do something that should be easy for a layman. And if the courts want to make it hard for a layman, well, then the layman will make it hard for the courts by becoming intelligent. Okay? Many of my grandfathers were Dutch lawmen, mayors, and congressmen, senators. In fact, my grandfather was one of the first mayors of New Albany, New York, Martin Van Buren. I come from the band, the Rennesslers family. So my grandfathers fought in the American Revolution. They ran a lot of the politics in New York in the 17 and 1800s. But let's get back on track. Depending on the situation, a judge is definitely, especially if they're getting irritated with you, they're going to ask you questions, that are definitely, they're going to ask you, were you speeding at that time? And you definitely object. This calls for self-incrimination and assumes facts not yet proven. The burden remains on the prosecution. They're going to ask you questions like that, and you need to be prepared. You can always just, I'm not answering that. That's your job to prove it. That's the state's job to prove it. Don't say nothing to the judge. You always just, objection. I'm not answering that. It's the state's job to prove it. And if you say objection, you definitely need to say for why. If you're going to call out objection, I'm not answering that. Just say it's speculative, and it's the state's job to prove it. They might ask you, do you have evidence you weren't violating the law? And they will ask you that. But be hesitant to answer. Just be firm and affirmative. I don't need to prove a negative. That's not my responsibility. You can be a little more friendlier with by using legal language. The defendant bears no burden of disproving substantiated allegations. They can't stand an informed defendant, okay? Why didn't you contact the court center? Maybe you didn't do anything and you're just standing in front of the judge, and you're trying to be a hardball and just do it right out the gate. They're going to ask you why you didn't contact the court. Say, I followed unclear instructions given and acted promptly upon reviewing my rights. That's a question I'm expecting. Why'd you file a dismissal so late? I'm a person who used the legal way, and I'm a start off the layman way. I followed unclear instructions given. I acted promptly, and after studying procedure and my rights, I made a decision. My decision is that official document that is quite clear and non-ambiguous in your hand, and you can say ambiguities in official documents cannot be held against a defendant. The responsibility to provide clear procedural guidelines lies within the state. That was my answer, because I put that into dismissal. You aren't giving me clear, defined any information. Your citation is so messed up, it's not funny. I've heard in court, did the officer give you a verbal warning or explanation? Never answer that. Not that I recall. It wasn't documented, then it cannot be so. Okay? That record lacks any formal explanation or affidavit. The court cannot rely on undocumented regulations. That's hearsay. Okay? I've heard, did you observe the speed limit sign? That's not relevant unless you prove I was speeding. Okay? That's the hardball way. And the legal way is relevance is contingent on whether the state can prove a violation occurred under legally sufficient evidence. Okay? Sometimes you can make comments that insinuate that the officer is lying without calling the officer a fucking liar. They're definitely going to ask you, and I've seen this 100 times, are you calling the officer, are you saying the officer lied? And I've always heard the same, this is the most common, I'm not saying nothing has been proven. And most of the time I hear a lot of, yes, I'm accusing the officer of lying. You don't want to ever do that. You get instant loss. Instant. You say, no such assertion has been made or will be made on the character of that officer. I request the court limit the inquiry to evidentiary standards, not personal speculation. Okay? You might hear, do you agree the vehicle is registered in your name? That might be, but ownership doesn't prove who is driving, and that's absolute. Vehicle registration is not proof of operation. The state must prove all elements of the charge beyond a reasonable doubt. And those are questions you have to be careful. You answer that question, yes, without telling them, but ownership doesn't prove who was driving. They're going to imply that you saying yes, you own the vehicle, and the vehicle's registered in your name is you were driving. They're going to imply it. You have to actively say, ownership doesn't prove who was driving. Okay, you have to tell them that. When they ask you, do you have a valid driver's license? Objection. That's unrelated to the specific allegation. You know, you can say my licensure status is not relevant unless directly tied to the facts of the allegation. So it's got nothing to do with speeding. It's got nothing to do with parking in a bad parking spot. You know, in my case, I'm expecting here. Why are you asking for a dismissal instead of a trial? And I'm gonna tell them, you know, dismissal is proper when no valid claim or sufficient evidence exists to support prosecution. You know, and that's where I'm at. You know, there's nothing up there. There's no evidence, no nothing. So I ask that this go away. 1 second. Let me go get my lizard. You a handsome lizard? Okay, so, you know, where were we? Okay. You know, in my case, I'm expecting to hear, why are you arguing the citation lacks evidence? And I'm a flat out say, there's nothing showing what actually happened. There's nothing here. And then I'm going to respond with the citation fails to meet evidentiary threshold required for a charge to proceed. No admissible or supporting documentation has presented. And then I will not answer any other questions that are speculative. I'm going to keep a list of them in front of me when I go to court. So that way, when I hear it, I can go through and say, okay, this is how I'm going to answer. You know, you have to do your due diligence. You know, like this one website that I was reading, very awesome. You know, you can't study an hour before court and win. You know, they have to be ongoing. You know, even judges have to study so many hours of court cases and legal studies a year to stay up to date on changes. You know, they ask you, do you want to negotiate a plea deal? Depending on your situation, I ain't here to negotiate something that hasn't been proven. You know, some of them might get you to try to accept a plea deal. Like with me, they sent me a plea of abeyance. They asked me to pay the fine and not get a ticket for 9 months. And no further action would be required. And I'm like, what further action? There's no criminal elements. There's no criminal stipulations to the other end of it. So why are you threatening me? I don't appreciate that. And I called it out with a dismissal. As soon as they sent it to me, I said, oh, yeah? Well, guess what? I dismissed because your shit don't say nothing. I asked for a dismissal, and you know what? Of course the judge didn't agree to it. And, of course, I haven't heard nothing back. They don't like an informed defendant. They don't like someone who's going to question their authority. They don't like someone who's going to try and do it the legal way. They don't like that. It pisses them off. That's why they give me the wrong court date. I was ready for court this morning. I'm like, why ain't I getting an invite? Called up there at 8 o'clock, and they're like, oh, well, it's because you're next week. I was like, okay, wrong date. I appreciate that. I appreciate him giving me the wrong date. That's wrong. And I got it on email. They give me the wrong date. So when you want to negotiate a plea deal, unless you have to, negotiations are premature or absent a valid case. I reserve all rights pending formal adjudication. All right? They ask you to, especially sovereign citizens, you're going to hear, will you stipulate to the citation's authenticity? Okay? Your best bet is not to come off with the off-the-wall shit. You say, no, that's the state's job to prove. You know, if you want to be simple and an asshole about it and uneducated. Or you can say, I do not stipulate to any documents or facts not properly introduced into evidence. Okay? They're going to ask you, are you representing yourself? You just say yes. I'm in propria persona. Okay, propria persona, which means in proper persons, and I reserve all procedural and substantiative rights, and I'm here ready for my administrative and procedural matters. And how may I assist you today? Think about using the phrasing, if it pleases the court, if it pleases the judge, if it pleases your honor. Be polite, but don't be weak. Be polite, but be aggressive and assertive. Okay? I've heard sovereign citizens go in and say, Your Honor, this is a civil equity matter, and we're in a criminal court. And you're definitely going to hear, are you asserting this is a civil matter and not criminal? A sovereign citizen uses that. Said, if it's not criminal, then why is the court treating it like one? Definitely include, based on the cited code and penalty structure, this matter lacks criminal elements, therefore criminal procedure may not apply. And if you're going to go to sovereign citizen route, you're much better challenging jurisdiction by going in and saying, structure your little showdown this way. Your Honor, I have a few questions before we get going, so there may be clarification and a clear understanding of which way I shall be going today. Ask them, what hat do you wear? Is it criminal or civil? Ask them what hat the court is. Is it criminal or civil? Ask them if your citation is civil or criminal. Because your citation, if it does not carry criminal penalties, it is not criminal. It's civil. And a lot of sovereign citizens will go, especially in states like Michigan, where the traffic infraction itself actually has the language, civil infraction, civil equity. And people will go in and say, Your Honor, this is a civil equity matter in a criminal court. How may we hear this matter? You can expect to hear, are you asserting that this is a civil matter and not a criminal? Absolutely, especially if you're not in a state that words on their citations that it's a civil infraction, okay? You have to study the cited code and the penalty structure and where the code is written and the codes around it, okay? Use other codes and words around something for clarification. If not, contact the court and force them to clarify. Write it in writing. Motion for the judge, courts to clarify. What jurisdiction do you have to bring this forth? Force them to prove jurisdiction. If you're going to argue, you need to argue the right way. You need to fight them the right way. Not with this, I have a right to fuck off on your laws. That don't work, man. It doesn't work. I've definitely heard myself, do you challenge the officer's training and observations? I challenge any unverified statements without evidence. Okay? No certified evidence has been submitted regarding the officer's qualifications or the reliability of their methods. I would definitely say, hey, what evidence of officers' training and observations does the state have to provide today to prove the officer's capabilities? And flat out say, when you ask it, say, Your Honor, right after they ask, before you ask to cross-examine, say, Your Honor, I've noticed no evidence has been entered for the officer's training or observations of his abilities, and I'd like to challenge any unverified statements without evidence. There's no certified evidence being submitted regarding the officer's qualifications or the reliability of their methods. In order to ensure without a shadow of a doubt that he's fully qualified to do his job and that his certifications are up to date and all of his equipment are up to date, we need to see those records and ensure that they've been properly maintained. you know, if you ask for a dismissal, you're definitely going to hear the, what outcome are you seeking today? And they're going to ask you that. Well, what are you hoping happens today? What are you expecting to happen today? And you just tell them, you know, you can just politely be, I like a fair process for the citation to be dismissed if it cannot be supported. You know, you can legally say, I respectfully request dismissal with prejudice for lack of sufficient evidence and failure to meet the required legal standards. You know, they're definitely going to complain about how long it took you to do something, and they're going to ask you, why didn't you respond to the citation sooner? And you can dumbfoundedly tell them, I didn't understand the process because it's not clearly explained. Tell them, procedural ambiguity and vagueness in the citation deprive me of a clear opportunity to respond timely. The burden lies with the state, not with me. If the judge asks you, are you prepared to testify? Tell them, not unless the court compels me and only if evidence justifies it. You know, invoke your right to remain silent unless proper evidentiary standards are met. If they don't have everything you need to defend yourself and build a defense, there's no point opening your mouth. You know, do you have any witnesses? I don't bring anything forth, and no witnesses are required unless the state presents a case that warrants rebuttal. If the state isn't living up to their specific performances, and there's no reason to rebuttal. If they don't push forth anything that needs to be said back against, shut your mouth. When they ask you, would you accept a reduction in fine when you send in a dismissal, and they're not going to like that. I can assure you they're going to ask you, would you accept a reduction in fine? And you just tell them, I'm not seeking a plea deal, I'm seeking justice. I decline to consider any remedial action until the state meets its initial burden of proof. You know, if they see it as sovereign citizen stuff, and I've heard this before, they're going to tell you, are you refusing to cooperate? And you say, I'm cooperating with the law. I just want it followed properly. I have constitutional rights. You know, and the proper way to say it is, I assert all rights under the Constitution and the court rules, including the right to challenge unsupported allegations. You know, they're going to be on you like Stinky on the Winky. You know, they're not going to be easy on you, and they're not going to be friendly. Come on, Mr. Greg. There you go, Mr. Greg. Have fun. You know, they're not going to take it lightly on anything. They're not going to take it lightly that you challenge them. I can assure you of that. You know, it's not going to be good. But you got to be affirmative, assertive, and stand your ground. You know, like questions to think about the officer's procedures when he's in court, you know, when he's doing the traffic stop. Questions you need to think about. Did the citation indicate the exact nature of the violation? Okay. If it doesn't, or it fails to add in specific performances, which in the form of a traffic infraction, it would be a code and then a subsection that specifically applies to that code that tells you exactly what nature of that violation was violated. All right. You could look at it this way. It referenced a general statute but failed to include specific factual allegations or methods of determination. Okay? So if you look at a citation and you're like, ain't shit on that. Motion for dismiss for lack of evidentiaries. And definitely a question you're going to probably hear is, did the citation indicate the exact nature of your violation? And you can expect to rebuttal that. You're going to you can expect to need to be rebutted, because they're going to ask all kinds of questions. You know, and some of these questions that I'm talking about in this video pertain to me and my specific situation. But needless to say, there's still common questions, because there's common things that happen in court every day. It's motions to dismissal, and watching videos on people who go in front of judges with motions. Just depends on the situation. But almost always, the lawyer or the defendant had to explain in quite good detail the purpose of the dismissal and why they think it ought to be passed and approved. In my situation, I'm challenging the citation as a whole. There was a lot of vague phrasings without clear instructions. It's very generalized. It wasn't in my favor. By no means. In fact, the language is very unclear and very shameful, I would say, in the eyes of law, because of how strongly it uses lack of phrasing and proper wording to throw you off and to cause you to easily have issues. And I don't appreciate that. They need to step their game up. They need to step their standards up. We have the right to due process, and we're afforded all these rights, but you get slacker and slacker as you go. That's an issue. They're going to ask you, did you receive a physical or a digital copy of that citation? Or any evidence with the citation? I guess in some states, they can provide you with evidence on the side of the road there, because you can provide them with evidence, I guess. They can upload your cams and stuff like that. But in my case, I wasn't provided nothing. I was provided a citation. I was not provided with an affidavit that said I needed to go to court. I wasn't provided with a court date. I wasn't provided with nothing. The burden went on me to have to call the court and set up a formal hearing to, in their words, contest the ticket. And when she said it, I was like, ma'am, I'm not contesting nothing. I have the right to a formal hearing on anything. And she said, yeah, contesting. I said, I'm not contesting. I expect a hearing and full procedural due process according to the Constitution. You are alleging something against me, and I expect you to prove it. I said, I'm just making you do your damn job. And right there, it was bias. And that's not okay, because that means she's mad that I'm saying I'm not guilty. And that's not okay. I have a right to say, prove it. If you're going to charge me a $380 fine and take money out of my pocket and money that I used to buy food to feed my kid, you're going to prove it, and I'm going to fight you all the way. But to them, you're just saying I'm not guilty, and it's pissing them off because you're not just paying the fine and shutting your mouth. They don't like that. They don't like it when you contest something. They don't like it when you're informed. They don't like it when you go study the law just like they do. I'm definitely have heard multiple times people contest, the writing and the language of a ticket. And some of these questions are ones that I've heard in several videos. Did the citation clearly instruct you how to contest or pay the fine? Absolutely not. In fact, the language is so vague, you figure it out. You explain to me how you're supposed to interpret this, that, or the third from this language when it doesn't have anything. This is what it says when this is a incomplete sentence with an incomplete sentence with an incomplete sentence. 3 incomplete sentences don't make a whole sentence of interpretation. Okay? Maybe in the administrative world it does, but in the legal and the lawful world it does not. It must be clear and adamant and direct and in a language understandable by the layman. Okay? It has to be understandable by the simple man. It cannot be ambiguous. It has to be clear and direct. Okay? Did the officer explain to you your options or court process when issuing a citation? No, he didn't. He just said, here you go. Slow down. That's no information at all. There's nothing. Nothing at all. How are you supposed to use any of that, to help yourself understand the situation? He didn't explain anything. He didn't explain what I did wrong. He didn't explain nothing. He came up to the window and asked me for my license and registration and asked me if I understood why he pulled me over. I said, I'm sorry, I can't answer any questions. He said, that's fine. He walked back. 10 minutes later, comes back with a ticket. Citation, making an allegation, and told me to be on my way. That's nothing. Was I notified of the formal hearing date? Yes, because I had to call and request it myself. So I wasn't informed of anything. I wasn't notified. I had to do all that. That's undue procedural burden. When they asked me, were I speeding or committing any traffic offense that day, I'm not going to admit to that. By no means. Why would I admit to that? I'm going to simply just say I'm not going to concede any offense occurred. There's no substantiative evidence or corroboration provided. There's no corroborating evidence because there's nothing written on the citation. What's up, Boogie?
I was in the garage and oh, you were making a video. I'm sorry.
No, you're fine.
But anyways, I was in the garage and when I came home, I made a noise and I was like, finally I'm home, something like that, and then heard something crawl in the ceiling.
Probably a bird.
Yeah, I kept making loud noises and it kept crawling.
Yeah, if you go outside the back door and look up, you'll see that there's a little bird nest up there where they're getting up in the attic. It's just birds. So for me, it's the court didn't do their job. You're charging me with a crime. You're saying I committed a crime, but nobody give me a court date. You just expected me to pay the fine without going to court. So you didn't give me a court date. You didn't even do your job. The officer, he didn't mention using radar, LiDAR, pace and visual estimation. He didn't mention anything. So, there's nothing disclosed on the citation otherwise. And how am I supposed to form a defense? You know what I mean? It lacks any mention of how the speed was measured. Then any later attempt by the officer to introduce the method into court can be challenged as a late disclosure and unfair surprise, violating due process. They have to follow order. But if they're not following order, you need to know how to object and file a motion to exclude the officer's testimony or method of speed detection. If it was not disclosed in the citation or in discovery, then it cannot be included into testimony when the cop gives testimony. It's because due process clause of the 14th Amendment requires fair notice of allegations and of the evidence. Okay, just entering it right at the end, Brady versus Maryland, and the rule of discovery or state equivalence require disclosure of evidence that may be material to guilt or punishment. Okay, rules of evidence varies by jurisdiction, but often falls in this guideline of prohibit the introduction of late disclosed or prejudiciary evidence that was not timely shared with the defense. Okay, and when they try to enter this during testimony, you need to object. When they go using blah blah blah, you say, objection, Your Honor, late disclosure. The citation does not identify the method used to determine the alleged speed, and this constitutes an evidentiary surprise that deprives the defense of due process and the opportunity to prepare. I move to strike the testimony and dismiss the charge. Okay. You should also include further, this testimony goes beyond the four corners of the citation and introduces harmful information not previously disclosed to the defense. It should be excluded as prejudicial. They can't enter it into evidence in the beginning and follow proper procedure. then it should not be allowed to harm me. If you want to file a pretrial motion, this is something you can anticipate, and it often does. You file a motion in limine, okay, before the trial to preemptively exclude testimony on any method not disclosed in the citation or discovery. You can title it Motion in limine to exclude late testimony regarding speed detection methods. Grounds, due process, procedural surprise, and failure to disclose. The defendant respectively moves this court to prohibit the state from introducing any testimony, documentation, or verbal method of speed detection, radar, laser, pacing, visual estimation that is not specified within the citation or provided in discovery. 1. The citation provided to the defendant lacks any mention of any method used to determine the alleged matter. 2. The introduction of such evidence at trial will constitute a late disclosure violating defendant's right to due process and opportunity to prepare an adequate defense. And 3. Allowing undisclosed technical testimony unfairly shifts the burden to the defendant to disprove claims made outside the original evidence record. Wherefore, the defendant respectively requests the court to grant this motion and exclude all testimony. Okay? It's critical that you pay attention to the citation the moment you get it. If motion to dismiss based on deficiency. If an officer's testimony is struck or excluded, and there's no other admissible evidence of speeding, Your Honor, without admissible evidence of the method used to determine alleged speeding, the state has failed to meet its burden of proof. I move to dismiss the charge under rule, in which you need to look up the state, whatever state you're in, and look up their local rules for evidence and their dismissal rules for insufficient evidence. And all you have to do is Google the state that you're in and rules for evidence, or just type in motion to dismiss insufficient evidence in the state, or the state first, and then motion to dismiss insufficient evidence. And a bunch of samples will come up, and you can use those samples to understand what the dismissal requires and how to properly fill it out yourself, and then to use it to protect yourself. Key points to emphasize here is the citation is a formal notice, and anything outside it is not fairly disclosed. Okay. Anything prejudicial must be entered then. After prejudicial, it becomes harmful, and it surprises you, the defendant, and you don't get a chance to provide a defense. The burden of proof is on the state, not the defendant, to fill in the blanks. Okay? If radar, LiDAR, any of that part of the accusation isn't disclosed and entered into evidence, and you know about it, you can't enter it into evidence after the fact. It's important to there's a lot that you need to do to protect yourself in court. There's a lot that you need to do to listen, because the language is the most important aspect. Phrasing. Phrasing is the most important aspect. You know, what is legal may not be lawful, okay? But just because it's not lawful, don't mean it ain't legal. And their language can easily be used and construed against them. If you listen to proper wording, you know, you're going to hear questions like, I used the radar, I paced the vehicle, I visually estimated the speed, laser clocked him at, you know, XYZ clocked her at. They're going to try and rephrase that. If you listen to that and you go, objection, it's late evidence, it's harmful to the defense, I motion to have this struck down and objected from testimony and dismissed. They will try to rephrase, I observed the defendant traveling faster than traffic. Objection. It's entered after the fact. I followed at a consistent distance and noted my speed. Entered after the fact. It's not on a citation. It wasn't entered into evidence before judicial trial. Entered after the fact. It's late. Objection. You know, based on my training and experience, I recognize the vehicle as moving above the limit. Objection. You know, the vehicle was going noticeably faster than others. Objection. Object, object, object. Late evidence. Inadmissible. They're always going to try and reframe and rephrase and reword a specific sentence to sneak in inadmissible technical testimony. By, you know, and you have to be careful because they're highly trained at this. You think, you know, this, that, and the third about them. No. This is their job. Their job is to train to deflect these and push this and say that and argue this and argue that. Okay? You need to learn to object to rephrased or late evidence. You know, objection, Your Honor. This is recharacterized of previously excluded testimony. So if you, you know, get method of mode thrown out, you know, later, objection, you know, all right, cool. And then he tries to rephrase it. You know, you're going to have to object to that rephrasing. This is a recharacterization of previously excluded testimony regarding the method of speed determination. It remains a late disclosed method, and this phrasing attempt to circumvent the court's prior ruling violated due process and procedure, prejudiciary producing the defense, okay, prejudicing the defense, okay, and you're going to want to use federal rules of evidence, okay. Most courts, state courts, mirror their language, you know, so it's going to be pretty similar. Rule 403, Federal Rules of Evidence, Rule 403, excludes evidence if its probative value is substantiatedly outweighed by the danger of unfair prejudice, confusing the issues, or misleading the jury. Okay? I think the window back there is causing issues. I might have to close it. Federal Rules of Evidence, Rule 602, witness must have personal knowledge of information. Discovery. They can't enter in late without using discovery first. Rule 701, lay opinion, testimony must be rationally based on perception and not based on scientific, technical, or specialized knowledge. Okay? And (702) expert testimony requires prior qualification and disclosure. They can't bring in an expert testimony. They must disclose, and you must have access to his testimony before, so you can make a defense against him or cross-examine him. You have a right to notice. Brady v. Maryland, citation 373 U.S. 83, 1963. Due process is violated when the prosecution withholds evidence material to guilt or punishment. Okay, a very important case. Taylor versus Illinois, citation 484 U.S. 400, 1988. Courts may preclude defense or prosecution from using untimely disclosed evidence or witnesses as a sanction. Okay, Wardius versus Oregon, citation 412 U.S. 470, 1973. Criminal due process requires reciprocal and fair disclosure. The State versus Pena, citation 896, P2D 932, Utah, 1994. The Utah Supreme Court upheld sanctions for a felon to disclose evidence, especially if that failure creates prejudice to the opposing party. Okay? If you're going to file a pretrial motion in Lamine to prevent late rephrasing, the defendant anticipates that the state may attempt to introduce into testimony from the citing officer regarding the method used to determine speed, either explicitly or implicitly. Defendant respectively moves this court to prohibit such testimony unless it was clearly disclosed in the citation or discovery materials, allowing rephrased or technical testimony under the guise of training or general observation constitutes late disclosure, prejudices the defense, and violates the principles of fair notice and the due process under Brady, Taylor, and Utah's discovery rules. Well, again, we're using their laws and their language against them. Okay, that's the point here. When they say based on my training, you object, Your Honor. That's expert testimony, not disclosed under Rule 702. That should have been disclosed pre-trial and discovery. They did not. They did not offer that as the evidence. They did not offer anything like that. So, and they never do. You're not going to see that in a court case, not unless there's a specific reason why there's going to be expert testimony. But right there, you take out their opportunity to testify against you by taking away their testimony. You got to defeat them with their own words. When they say something like, I could tell they were speeding. Objection. Vague and speculative. The method of speed determination was not disclosed in advance. I visually estimated. Objection. Lay testimony involving technical assessment without proper disclosure. I followed them at 55. Objection. This is pacing, a speed detection method not cited or disclosed prior to trial. No matter what, don't let him get in the language required that he thinks he needs. Don't let him get anything in. If all else fails, motion to strike and dismiss. Your Honor, if it may please the court, even after the court excluded the original testimony, the plaintiff has attempted to reintroduce it under different phrasing. I respectively move to strike this testimony and ask the court to dismiss the charge for failure to provide the defendant fair notice and a meaningful opportunity to prepare a defense per Brady and Taylor and FER 403. Okay? And it's important, because one thing that you'll definitely notice a lot of is lay opinion testimony. Particularly, it must be rationally based on perception and not on scientific, technical, or specialized knowledge. This is a powerful tool in traffic court and all courts when objecting to police officers or witnesses testifying as pseudo-experts without proper qualification or disclosure. Federal Rule of Evidence 701. If a witness is not testifying as an expert, testimony in the form of an opinion, it is limited to that one that is A, rationally based on the witness's perception, B, helpful to clearly understanding the witness's testimony or to determining a fact and issue, and C, not based on scientific, technical, or specialized knowledge within the scope of Rule 702. Okay? What this means is a lay witness, like a police officer, civilian, or anyone not testifying as a qualified expert, may offer opinions only if they personally perceive the fact, saw, heard, smell, etc. Their conclusion is obvious and common sense. He looked drunk. The car was loud. Their opinion does not require specialized training or technical analysis. Okay? What is not allowed in lay testimony? The following examples cross into expert territory and should be excluded unless the witness is qualified and disclosed in an expert under Rule 702. Estimating speed based on training. Example, I estimated 63 mile an hour using my radar training. Okay? They need to explain how the radar or LiDAR works. They need to explain analyzing braking distances, momentum, impact forces, define defect patterns and tire skid marks, offering opinions. If they start explaining how radar and LiDAR works, it's not allowed. Okay? They didn't enter into testimony as an expert witness. Okay? They're not allowed to estimate speed based on training. They're not allowed to explain that. They're not allowed to explain how the radar or LiDAR works, not unless you ask them a question specifically, which you should always test them as on a radio second class operator's license, which is used for a radar LiDAR. You test them on those tests and see how many of them questions he gets right and how many he can't answer at all. If he's analyzing brake distances, momentum, or impact forces, he's trying to identify defects in tire skid marks, offer an opinion on signal timing patterns or traffic flow theory. None of that's allowed. Okay? Here's an example. Police officer in traffic court. What's allowed? I saw the vehicle go past me. It appeared to be going faster than the rest of traffic. Okay? Not based on my training in radar and visual speed estimation, the car was going 68 mile an hour. Okay? The second example is based on specialized knowledge of speed estimation. It violates the Rule 701C. Unless the officer is properly disclosed and qualified under 702, expert testimony is not allowed. United States v. Figueroa Lopez, 125 F3D 1241 in the Ninth Circuit Court in 1997. DEA agents gave opinion testimony on drug trafficking behavior. Court ruled this is required expert qualification, not lay opinion. Okay? In State versus McGilton in citation 145, New Hampshire 316 in 2000, officers' testimony that a driver appeared to be under the influence was admissible as lay opinion, but specific explanation of breathalyzer readings was not without expert qualification. So, if he tries to give his expert opinion on something in your case, you can. Federal Rule 702 says he must be entered in as an expert witness, and his qualifications need to be entered as well. Okay? So think about that in a traffic situation. That citation is his testimony, and he's being entered in as an expert witness. So if they're going to enter him in as an expert witness, they need to enter in his qualifications and enter him as a expert witness, because he needs to be other than that, you have to be careful with the language of his comments, because they're just lay opinions. Okay, so this is where you need to learn how they talk and their phrasings, so that way you can understand when they're speaking out of context, and you can get it used against them. Okay, People versus Beckley, citation 185, Cal App 4th 509, 2010. A police officer's training-based conclusion about driver speed based on visual estimation is not admissible as lay opinion under California Mirror FOR3 FRE Federal Rules of Evidence 701. So even California upheld that an officer's training based conclusion about driver speed based on visual estimation was inadmissible. And California is very liberal, and even they're like, it's not admissible. Okay, that's just lay opinion. You can object to him in court. His testimony is based on scientific or technical knowledge, specifically radar operation and speed estimation training. Under Rule 701, lay opinion must not rely on such knowledge, and the officer has not been qualified or disclosed as an expert under Rule 702. Okay? You can do a pretrial motion, and it's suggested, motion in limine. A defendant moves to prohibit the citing officer from offering testimony that constitutes expert opinion, including but not limited to radar, lidar, pacing, or visual speed estimation based on training or expert, unless the witness is disclosed and qualified as an expert under Rule 702. Such testimony exceeds the scope of permissible lay opinion under Rule 701 and must be excluded. Okay? And I know a lot of times they're going to complain about the timing of you entering information. I don't care. You know what? You're a layperson. Court should be thankful that a layperson is attempting to be proper. You know, they should be thankful and kissing your ass, in my opinion. You know, for a layperson to go out of their way to try and learn that filthy language, legalese that they use to defend themselves, they ought to be thankful that somebody doesn't want to be stupid and ignorant. I get that it pisses them off that it messes with their momentum of monetary collections, but you know, whatever, you know, just think, whenever the prosecution tries to slip in testimony with technical language, ask yourself, does this require training to understand? Would an average person know how to do this? Is this something you could testify to without certification? And if the answer is no to any one of them, then it's not lay testimony, and Rule 701 bars it without expert disclosure, okay? So think about that. You know, do you believe the officer had probable cause? There's no articulatable probable cause or evidence to justify the charge on the citation. So I can't answer that question correctly. You know, they might ask you, are you aware of what the statute or code you allegedly violated? The citation referenced the general code, but without factual specifics, the elements were not established. You know, and for my case, they wrote down the statute, but the statute has 7 performances. And one of them must be stated for me to build a reasonable defense. So for me, no. But we are going to get into some more later. And that's for another video. And we're going to continue down talking. And we're going to start at section B with the legal and procedural questions, and we're going to talk about this stuff. And we're going to go deep diving. And again, like and comment below. Anything that you want to talk about, let me know. I'll be more than willing to conversate back with you. I got no issues with that. You know, follow me. Subscribe for all my videos to come out. They might be long and they might be short. Who knows which way they're going to go, but it depends on the subject. If there's something you'd like to do a deep conversation with, or even do a video where we're both together talking and do a discussion live, I'm okay with that. That's cool. I'm not super intelligent, but I damn sure like to learn. And if there's something that you ask me that I don't understand, I'm going to go find out so I can understand and conversate back. You know, I like to learn. Let's get together. We need to work together to start our own constitutional party and fight the courts in specific manners and receive specific performances back. You know, we need to fight, but we need to do it the right way. We need to do it the legal way, and we need to be prepared. So, you know, finding questions like here, reading them, you know, asking how the proper way to answer them is, you know, asking for questions with proper responses, asking for multiple responses. What's the wrong way? What's the most common way that someone answers this question? You know, ask. Use AI to your advantage to help you find cases that you need to study for your argument. You know, it's handy. It's taught me a lot because I can ask it questions when I get confused while watching a court case. You know, and get it to explain things. And that's what led me on my path to defending myself in a court of law. Is, I got looked up the code, and I was like, and then I looked at the citation. I said, "There's nothing here for me to even attempt to defend myself." So I started studying motions to dismiss and evidence, and I started learning all of this stuff. And something I noticed right away was something they call quasi-judicial courts. I was like, it's very interesting, because it's not in the Constitution and it's not in any law book, but yet it's there. And if we're going to win, we got to learn to defeat it. We got to learn to fight it. We got to learn how to fight it. We got to learn how to talk. So, read some books. Get up with me. Like and subscribe. Comment. Let's learn. Let's go down this road. Let's take our country back. And I love you. And God bless you all. And remember, love God.